It's a distinct honor to be with you today. Deeply grateful to BCAS and its president CA Bhatia for giving me this opportunity. I will begin by providing the context and background of the IBC, followed by a brief discussion on its mechanism and performance to date. I will conclude by outlining one or two key steps for its future improvement. So we invented the companies in search of immortality because they would survive us and they would outlive us, carry forward our legacy forever. We empowered them, we made them modern engines of growth, custodians of nation's wealth. They provide us livelihood, they hold the promise of prosperity for posterity. But the companies are more than a bundle of assets. They have the assets, but they have something called organizational capital, the collective knowledge, wisdom, and systems that exceed their liquidation value. So when a company is shut down, we actually destroy not only the physical assets, but the hope and accumulated expertise. It takes years of effort to bring up a company to replace an existing one, and premature closure of many companies can destabilize an economy. The lives of the companies are in danger today more than ever before. The company which lived longest in the history, named Kongo Gumi, that was a Japanese firm engaged in temple construction, survived 1429 years before succumbing to death in 2006. A few 1000-year young companies still exist today, but they are rare, surviving gems of an bygone era. Contrast this with modern trends. The average lifespan of a S&P 500 company has declined sharply from 90 years in 1935, I'm quoting an Yale University study, to just 18 years in 2016. Recent studies show that the average lifespan of a publicly traded company, considering mergers, acquisitions, and bankruptcies, is now approximately 10 years. This poses significant challenges to companies, economies, and the societies. The life of a company has several enemies. I am not getting into them. Suffice it to say that the most fatal enemy is competition and innovation. And it is the state policy to promote competition and innovation because they are the prime drivers of growth. In competition, efficient firms kill inefficient ones, and in innovation, new order kills the old order. So we are in a catch-22. We want competition and innovation for growth, but there are risks to the lives of the companies. Ideally, a company must not die before it is due. It must live its full economic life if it has a viable business. It must be rescued if it is facing any danger despite having a viable business. On the other hand, a company that has lived its full economic life and therefore is no longer viable should be facilitated to exit at the earliest. Viable companies should not be allowed to die, and unviable ones should not be allowed to live. This is what Insolvency and Bankruptcy Code provides. It provides a market mechanism for reviving failing but viable companies while allowing unviable ones to exit with minimal disruption and cost. And it does so in two ways. First, by attempting to rescue the company through a resolution plan, failing which, after the attempt fails, by the closure of the company through liquidation. If the company has a viable business, it should be possible to revive it. The IBC provides a CIRP that enables the market to find a feasible, viable resolution plan to revive the company as a going concern. If the company has an unviable business, the market is unlikely to find a resolution plan. In such a case, the company undergoes a liquidation. So let me emphasize here that both resolution plan and liquidation serve the same economic purpose, They resolve the stress by putting the resources to optimal use. It does not matter whether stress is resolved by way of a resolution plan or by liquidation. Liquidation is a legitimate means of resolution of stress. So why I'm emphasizing is that the Insolvency and Bankruptcy Code has only one objective, and that is the stress resolution. And if the stress is resolved in the manner IBC provides, it maximizes the value of assets, fosters entrepreneurship, promotes credit availability, but the objective is only one, and that is the resolution, which can happen in either of the two ways, either resolution plan or liquidation. Now let me give you one or two important principles what makes this mechanism work. First, it is the rights of the stakeholders. A company uses contracts to borrow, to leverage, to take advantage of the leverage. It enters into a series of bilateral but incomplete contracts which allows every creditor foreclosure rights over the firm's assets in lieu of credit. Every creditor feels comfortable on a standalone basis and extends the credit to the company. Every one of them has a foreclosure rights against the same business, same assets, and company meets the commitments towards each creditor in normal course and life goes on. But if the company is stressed, it does not have enough to discharge the obligations of every creditor fully. It can honor claims of one or a few creditors fully, but not all creditors simultaneously. Then elementary economics tells that there will be a queue of creditors, a run on the assets of the company. Creditors will rush to recover the claims before others do, triggering a run, like a run on the bank. So they will recover on a fast come, fast serve basis till the assets of the company are exhausted, bleeding the company to death. And this is a negative sum game. If creditors stick to their pre-insolvency rights, neither resolution of stress is possible, nor can a creditor realize its dues. The insolvency framework endeavors to resolve the stress while discharging obligations towards creditors to the extent realistically possible. For this purpose, it overrides the pre-insolvency rights and entitlements of the parties. It prioritizes claims of stakeholders in a hierarchical order, which we call priority rule or waterfall in our context. But more important is that this priority rule, once it is let down, it overrides over every other law. So overwriting the rights and overriding the other laws are essential features of insolvency frameworks worldwide. But it, however, does not ignore the pre-insolvency rights of stakeholders completely. It does not, for example, put unsecured creditors ahead of secured creditors or put them at par. So the insolvency law is an overarching contract that completes all incomplete bilateral contracts, makes claims of all creditors consistent, and prevents a value reducing run on the assets of the company, and thereby tries to rescue the debtor as well as the creditors. The second aspect I would touch upon is that it is a market process. Insolvency is an outcome of market process. Market must find a solution to it. State will have no role. A real sector company typically funds its operations through debt and equity. Ideally, the shareholders and the creditors should safeguard their stakes associated with the credit, with the debt, and the equity, respectively. But this was not the case till IBC came. The shareholders retained the control over the company even after equity was fully exhausted. The code rebalanced the rights of stakeholders, considering that what is left after equity is exhausted belongs to creditors. It allows the creditors to decide the fate of the company. They take over the debt laden company and they drive it is because they are supposed to have the commercial wisdom. They must decide the fate of this company. But to enable them to do so, the code confers extraordinary powers on financial creditors, because the objective is rescue the company if possible. So they can seek the resolution plan from the global market, unlike the previous regime where the creditor was constrained to have a deal only with the existing promoters. The creditors, they can take or cause a haircut of any amount to all or any of the stakeholders as may be necessary to rescue the company. And the resolution plan can entail anything and everything that resolves the stress of the company. It can mean change in management, technology, or product portfolio, acquisition, disposal of assets, businesses, undertakings, anything you can imagine, like the turnaround, buyout, merger, amalgamation, acquisition. But yet, some of the companies may be beyond repair and must be closed. The code facilitates the orderly liquidation of such companies. Now let's see how this code has worked over the 7 or 8 years. As I just mentioned, IBC has rewritten the rights of stakeholders in a company. Naturally, it has created both winners and losers. Those who used to benefit from the old order are likely to resist it. They tend to use wrong metrics to show IBC in a poor light. For example, they use the recovery as a performance metrics for IBC and claim that IBC is recovering merely 35% of claims, which according to them is a poor outcome. Please note that IBC is not a recovery mechanism. The code nowhere uses the word recovery. So why should one use recovery to assess the working of IBC? Even though in terms of recovery, IBC delivers better than any of the recovery mechanisms in the country. But there are also fundamental issues with the way the recovery of 35% is computed. There is overestimation of the denominator, underestimation of the numerator. Several items are left out, like the realizations from guarantors, equities, avoidance transactions. But the World Bank estimates, when we say that we are recovering 35%, the World Bank says that India recovers 72% from the IBC process. So it makes sense, therefore, to look at not the realization as compared to the amount due, but to the tangible assets available on the ground. Because market will offer a value, resolution plan will offer a value for the asset the company has and not what it owes to the creditors. Seen from that perspective, IBC is realizing about 165% of the value of assets of the companies, meaning that it is realizing 65% more, which is actually the organizational capital. If these were liquidated, that 65% would have been destroyed. Some other beneficiaries or some other critics, they use the high incidence of a liquidation to paint a negative picture of IBC's performance. This overlooks the fundamental aspect of the IBC, that it offers two legitimate modes of resolution plan and liquidation, and it is the market which makes the choice. So we can't be grumbling that X percentage of companies are getting liquidated, because that is the way the law envisages that the system should work. Nevertheless, though in terms of number, a large number of companies are getting liquidated, but if you look at in terms of value, 80% of the companies with value, in terms of value, 80% of the value of the assets are getting rescued. And more importantly, the companies which are getting rescued, one third of them were already defunct or in BIFR regime. And the companies which are getting liquidated, three-fourths of them were defunct or under BIFR. The companies which are getting liquidated had On average, assets valued at 5% of the claims when they enter into the IBC process. So if a company has been sick for years, left with the 5% of the assets valued at 5% of the claims, the market is likely to liquidate it. So the metrics and the methodology for appraising the IBC should align with its objective, which I just mentioned, the stress resolution. So the primary parameter for assessment must be whether IBC is resolving stress, irrespective of the mode of resolution, either resolution plan or liquidation. And on this critical parameter or the objective Parliament envisaged, the answer is unequivocal yes. There are secondary parameters like efficiency and efficacy of such resolution. IBC envisages two efficiency parameters. One, resolution must be time bound, and two, maximize the value of stressed assets. The performance on these efficiency parameters is less encouraging. It's much below the expectation. Another efficiency parameter is the cost of resolution, which is not bad, about 1.22% of the liquidation value or 0.76% of the resolution value. But as regards the efficacy parameter, the quality of resolution, a recent IIM Ahmedabad study finds it to be too good. Post-resolution, the companies have witnessed significant improvements within 3 years of the resolution. Turnover increased by 76%, profitability ratios converged with the benchmarks, and market capitalization tripled. The tertiary parameters like the efficiency and efficacy of the IBC in dealing with broader macroeconomic issues. The NPA of banks, after peaking at 11% in September 18, reduced to a less than 3% by June 2024. Banks collectively recorded a profit of 3.2 lakh crore in 23-24, as opposed to a loss of 32,000 crore in 17-18. Companies improved performance, leading to a robust balance sheets with prudent leverage and interest coverage ratio exceeding 3.5. What has made the difference is the Section 29A. The credible threat of losing a company motivates debtors to take proactive measures somehow to avoid coming close to the NCLT. The evidence is 30,000 applications being withdrawn after filing before admission. The code has brought such significant changes, making the Supreme Court observe in Swiss ribbons that with the code in place, defaulters' paradise is lost. In fact, the best use of the code has now been not using it at all, because on the shadows of the code, people are resolving the stress or repaying clearing their defaults. I'll touch two issues which has become one key issue in the context of the home buyers, and which has become a little problematic because a large number of companies, they have gone into this process, the real estate companies, and not delivering the homes that was promised. So IBC deals with real sector companies, not with the financial service providers. Real sector companies finance their business with debt and equity. Financial service providers fund their business with the client money, depositors' money, with a minimum regulatory requirement of debt and equity. So IBC is not made for financial service providers, for which a new law is in making. But IBC, since it does not envisage much of the client money, it did not explicitly provide to deal with them in its priority rule or waterfall. So creditors, they assume more risk than customers, but less risk than the equity holders. So among creditors, secured creditors rank higher in the distribution due to their lower risk compared to unsecured creditors. In the real sector companies, which typically do not hold customers' money, customers do not explicitly figure in the waterfall, or they are grouped with the operational creditors. But in case of financial service providers, customers' claims are prioritized at the top with additional protections from the state and insurance mechanism to avoid any shortfall. But law did not envisage that there could be, in Indian context, does not happen elsewhere, another set of entity which could be hybrids of real sector company and financial service providers, because they could conduct business using a combination of debt, equity, and customer money. And the real estate companies like the home buyers business is an example of this category, because they have adopted such financial and contractual innovations to fund their projects that they sell the under construction homes, allowing them to collect the sale proceeds in installments, and then they use that fund to finance the ongoing construction. This model worked well as long as real estate companies delivered homes within the promised time frame. But challenge emerged when they failed to deliver, and in response, IBC was quickly amended to classify home buyers as financial creditors, ensuring that they could participate in the decision-making process. This amendment offered some respite but introduced new complexities by vitiating the basic structure of the IBC, in fact, in the classification of creditors. The most critical was the situations where the insolvency failed to deliver homes or the company proceeded to liquidation, leaving home buyers without the resolution they hoped for. An effective solution would be to adopt the waterfall mechanism from the financial service providers framework, which prioritizes the interest of customers over those of other claimants who assume greater risks in supplying funds. This approach would ensure that customers, including home buyers, have their economic rights statutorily protected rather than being involved in the commercial intricacies of insolvency resolution. I'll touch one more aspect very briefly. The law, as I told, aimed to have one objective called the promotion of entrepreneurship. IBC provides a comprehensive framework for stress resolution of corporate entities, proprietorships, partnerships, and individuals. India has an estimated 1.7 million companies, but 170 million proprietorships and partnerships, and 1400 million individuals. However, the IBC is currently available only for corporate entities, covering a mere 0.1% of potential beneficiaries. Nearly a decade after its enactment was in 2016, proprietorship, partnerships, and individuals representing 99.99% of those who could benefit from IBC still lack access to the code. So this, we have, the IBC came as a measure to provide the freedom of exit. The freedom of exit or freedom from failure is critical for small ventures. This 170 million proprietorship and partnerships that serve as breeding grounds for entrepreneurship. They operate with razor thin margins. They are susceptible to failure. Studies indicate that nearly 90% of startups fail within their first 5 years. And there's a deep-rooted stigma surrounding failure in Indian society that compounds the challenges. So entrepreneurs, fearful of social judgment, hesitate to seek help, allowing their struggles to fester till it is too late, and in most cases, this pressure has led to tragic outcomes, including suicides. The extending the safety net that is available in the code to small ventures would empower them to restructure viable businesses and close unviable ones, thereby optimizing resource allocation. This will rescue the entrepreneurs from failure, unlock the full potential of entrepreneur spirit of India. Then only can India truly celebrate honest business failures, and that can put India on a higher growth trajectory. So this is all I wish to share. Thank you, BCAS, once again for giving me this opportunity. Thank you.
Thank you, Sahuji, for your very, very insightful understanding of the IBC. Uh, Friends, the Sahuji has provided valuable insights on the facts and myth of the insolvency code, backed by the statistics. His 360-degree evaluation of the progress and achievement of the insolvency code has now set the tone for the next sessions. His profound understanding of the evolving legal and regulatory framework within the insolvency domain has been truly enriching. I, on behalf of the Bombay Chartered Accountant Society, extend our heartfelt gratitude to Dr. Sahu ji for his insightful and enlightening keynote address on navigating the insolvency and restructuring landscape. And may I now introduce the speakers for the next sessions, which is Dhinal Bhai and Anil Goel ji. Friends, Dhinal Bhai is a practicing advocate and is also a chartered accountant by qualification and has more than 30 years of experience in advising clients on taxation, exchange control, insolvency, and corporate law. He is a former partner with EY and is the executive committee member of the International Fiscal Association. Dhinal Bhai was a Central Council member of the ICAI, the director of IPA and RBO formed by ICAI, and the chairman of the Direct Tax Committee of the Gujarat Chamber of Commerce and Industries. He was also the secretary of the ITAT Bar Association Ahmedabad and a visiting faculty at IIM on professional topics. He has addressed and presented various papers at seminars and is also a regular contributor of articles to various professional journals. Friends, I also take this opportunity to introduce CA Anil Goel, who is the founder and chairman of the AAA Insolvency Professional, one of the first two insolvency professional entity recognized by the Insolvency Board of India. Is presently the vice chairman of the SOCHM National Council for Insolvency and Bankruptcy and Valuation, and was member of the working group established by IBBI for implementation of individual bankruptcy in India. He was also a member of the SEBI group as constituted by IBBI for interaction with SEBI, NSE, and BSE for seeking concession for companies under insolvency process. His expertise in IBC and SERFACI, coupled with his in-depth knowledge and ability to simplify legal complex financial concept, is unparalleled. He has delivered various speeches at seminars and participated in deliberations and is also author of various publications on IBC. Friends, I will now request Dhinal Bhai to address the member on the topic. Welcome, Dhinal Bhai.
Thank you. Thank you, Bombay Chartered Accountant Society. And I'm actually a member of the BCA since 91. And I've attended almost all RRCs except Central Council role of for 9 years. Otherwise, it is love to attend BCS RRC both on the international ITF and the normal RRC for every member. So thanks, Anand. Thanks, Kinjal, for this opportunity.
Thank you,
And I
Dhinal
must
Bhai.
admit, and my co-speaker, Anilji, and I must admit one thing that whatever little I understand about IBC, the entire credit goes to Mr. Sahoo, the then chairman of the IBBI, who encouraged me. I learned what is creditor, what is corporate data. That terminology itself was a difficult terminology for me to understand. But somehow I learned and have practiced for few years. I must admit one thing from the IBBI and the government perspective, the way in which they have encouraged the professionals of chartered accountant, cost accountant, companies and advocates to play this vital role of a resolution professional. So the first and foremost opportunity we as chartered accountants are encouraged is to play a role of a resolution professional. Now, resolution professional by the role is a link between the corporate debtor, the creditors, the COC, and the potential buyer of this particular SIC unit or a unit which has undergone an IBC process of CIRP. So he actually plays a de facto role in his role as a resolution professional, and he supports the COC in taking the prudent decision about whom to encourage and who can buy this particular unit under the CIRP process. Initially, one may feel that role is very, very simple, but my personal experience and personal view, and also the expectation of the regulators, 3 or 4 things are very, very critical for any resolution professional. The first and foremost is understanding the role of a resolution professional, which travels beyond your normal role of an audit, tax, valuation, forensic, project finance, etc., etc. Just to give you a classic example, that when you do an audit, you raise questions to the client, and client is expected to give you the documents and answers. Now you are on the other side of the table. You have to find the solution to the problems which arise on a day-to-day role. So for 180 days or for 270 days or beyond this, whatever role which an RP is expected to follow, he has to follow like a de facto CEO or a prudent businessman, that how do you keep the company on a going concern and at the same time keep the business, keep the employees, keep and have relationship with the suppliers, customers, regulators, and then ultimately find out the prudent buyer who is willing to take over this particular unit under CIRP. And therefore, it is a very, very critical role. Let me give you a simple example, that if the particular chartered accountant is appointed as a resolution professional by an NCLT order and he takes over that unit as a resolution professional, the custody of assets, custody of books of accounts, custody of the technology platform, the emails, coordination with the existing promoters, coordinating with existing CFOs, CEOs, or a marketing head, or an employees becomes very, very critical. Because ultimately, under the law, the resolution professional is responsible for everything, and at the same time, he is not expected to delegate his powers in the role. He can always take a support of any other chartered accountant, company secretary, lawyer in performing his duty, but he cannot say that I relied on him and therefore I am not responsible. He is responsible for everything during the CIRP period. And therefore that role becomes very, very critical. Now, as an RP, when he takes over a particular unit as a resolution professional and he constitutes a COC, he has to first coordinate with the COC about the claims, about the custody of the assets, about the present status of the business, whether a business is able to generate a cash flow to meet expenses, to meet its own fees. Sometimes the business is not able to generate a cash flow to even meet his own fees as a resolution professional. And at that point of time, the lenders have to actually infuse money to meet the expenses and to pay the resolution professional fees. And therefore, it is not only your competency as a chartered accountant, it is also about your soft skills, your solution-oriented approach that becomes very, very relevant as a resolution professional. Here, you are not there to only raise questions. Questions will come on a daily basis, and you will have to find a solution in consultation with the promoters, in consultation with the staff, in consultation with the experts on the subject, including the regulators. If there is no solution to any questions, go back to NCLT, seek guidance, and then find a solution. Now, in this process, there are other roles which the professionals are able to play. The first role is verification of the claims. Every resolution professional has to verify the claims of the creditors, which would include the secured, unsecured creditors, suppliers, etc. Many reconciliation issues will arise. In the books of accounts, there would be 100 rupees. In the actual claim, it could be 300 rupees or it could be 50 rupees. So one will have to ascertain the actual claims. Otherwise, the creditors can go back to NCLT and say that the resolution professional has not accepted my claim wrongly. And therefore, verification of the claim is one of the most important aspects, because that will help ultimately to decide what could be the resolution plan and what could be the potential buyer is willing to pay and what is the haircut which a unit is expected to do. And therefore, verification of the claim is very, very important. The second is, in many such companies which are under CIRP, the accounts are not up to date. The accounts are written, say for example, today we are in January 25, the accounts are written only up to 22. The financial statements are not prepared. Same are not filed with ROC, same are not filed with Income Tax Department. If it is a listed entity, no compliance has been done with the stock exchange and SEBI. And therefore, you will need a cooperation from the promoters. Now, here, the cooperation from the promoters and your soft skills are extremely critical. Promoters, by their temperament, would not accept the reality that from the day on which the RP has been appointed, he is not having any powers to sign checks, he is not having any powers to take any final decision. If he wants to take any decision, he has to go back to RP. And humanly, this becomes practically difficult for any person who has been running the business for last 25, 30, 40 years. And on one fine good morning, one says that he is no more a decision maker. And therefore, there your soft skills, your solution-oriented approach, how do you keep the promoters to support you in your role as an RP? Because many business decisions, many regulatory-related decisions, many employee-related decisions are all taken by the promoters or the existing directors. And there, if you do not get a support, then you find difficulty in performing your role. And therefore, if you can always take a support of a professional chartered accountants to write the backlog of the accounts after taking the help of the existing accounting team and the CFO. The existing CFO and the accounting team also you will find a resistance, because in many cases the salaries are not paid in time. The 3-month salary, 4-month salaries are outstanding. Many times they do not see a future very bright. They do not know whether a new buyer would be willing to continue this business as it is, or he is buying for some other purpose. And therefore, the resistance from the existing team would be there. And there you can always take the help of a chartered accountant to clear your backlog on the financial statements, because under the law, it is a responsibility of the resolution professional to comply with all laws and regulations. And therefore, whether it is a GST compliance or whether it is a TDS compliance or whether it is filing of accounts and filing of tax returns with the ROC, with the Income Tax Department, with the GST department filing the returns, that is his primary role to comply the law. And therefore, there also you can seek an help of a chartered accountant who has a practice of writing books of accounts, who understands the past legacy issues, and then after taking the help of the existing staff, if there is a CFO with a CFO or a financial controller, you can try to finalize books of accounts to the extent possible. And you may not be able to clear everything, and then let auditor make certain observations, qualification depending upon the materiality and compliance to the accounting standards, auditing standards. He can finalize the financial statements. After that, the resolution professional is expected to invite the resolution plans from the potential buyers. In this process, this is more we call investment banking activities. And therefore, our chartered accountants who are having a good practice on investment banking, who are good on finding out the potential buyers, because there are many companies who are interested to buy the companies under NCLT, under IBC, because they believe that they are able to get this company at a reasonable rate. As per the established law, they get a company with a clean slate, no past obligations, either a statutory or a non-statutory, and they are able to revive this company. Many businessmen are so experts in reviving the business that they are able to get company at a much lower rate, and they are able to revive companies in 1 year, 2 years, 3 years to get the company. So the chartered accountants can also play a role of an investment banking to support the resolution professional, help him in preparation of an information memorandum, circulating to the potential buyers, the private equity, the strategic buyers, etc., to find a good potential buyer who can submit a resolution plan. And this is one of the most important role which a chartered accountants can play, from preparation of an information memorandum and then finding out a potential buyer from the market. If the size of the corporate debtor is large, they can also explore the potential buyer from the overseas market, or if the, depending upon the size of the corporate debtor, depending upon the criticality and the going concern, the people would be willing to invest money and to take over certain corporate debtors unit which are under CIRP. Now, before the information memorandum is prepared, the another role which a chartered accountant can play is a role of evaluation. Under Section 247 of the Companies Act, a registered valuer is allowed to do a valuation of shares. The same principle is followed even under IBC. So a registered valuer can do a valuation of what is the fair value of the corporate data. Now, when he does a valuation, many times the challenges are about availability of a reliable information, and therefore the valuer's judgment in valuing the corporate data becomes very, very important, because many times the fixed asset registers are not properly written. There is no reconciliation between a physical assets and a fixed asset register. There is no information about the realizability of an investment made in subsidiary companies or an overseas companies or a joint venture companies or an associate companies. There is no information available about certain realizability of the debtors. Many times there are certain differences in the quantity of the inventory, what is there in the books of accounts and what is actually available in the physical. And therefore, the valuer finds difficulty in valuing the company, and therefore his judgment in valuation of a corporate debtor on a fair value basis becomes very, very critical. And you need actually the good understanding of the business, good understanding of the information, and then subject to the limitation of information, the valuation is also a very good area of practice which chartered accountants can follow. Similarly, the role of the chartered accountants could be useful even for a forensic audit, because under the law, the RP is expected to certify that is there any preferential transactions, or is there any undervalued transaction, or is there any external transaction. Now all these transaction ultimately boils down to, is there any fraudulent transaction which our promoters have undertaken? Like for example, a promoters expected that I may not be able to survive this company for a long period. He would have transferred certain assets, he would have transferred certain investments, or he would have given a loan to certain related parties. There could be a diversion of funds. All these issues are a part of a forensic audit report. Now, I have seen in my practice that many times many chartered accountants are going by what is available on the face of the records and are certifying the forensic audit report. But in reality, those forensic audit reports may not be actually reflecting the ground reality under the table. And therefore, I would urge all members that when they play a role of a forensic audit, see, the difference between an audit and a forensic audit is that in a normal statutory or internal audit, you trust the documents, you take them at a prima facie value, unless you feel there is a doubt. And that is what the auditing standards say. But in a forensic, you start with an investigation, you doubt every document, you doubt every transaction, and satisfy yourself that yes, there is nothing hanky-panky. There is no role which a promoter has played in diversion of funds or selling of an asset as a much lower value than a market realizable value. And therefore, the role of a chartered accountant in a forensic audit is also very, very important. Today, all of us know that in every, either it is a SEBI or any regulators, enforcement director, PMLA, income tax department, GST, the forensic audit has increased their coverage in a much larger and more area. And therefore, this is again a good area of practice for a chartered accountant to do a forensic audit role. But I must admit also that, as I said earlier, that when you do a forensic audit, please do it with all professional competence, prudence, and skepticism, so that the correct forensic audit report and whatever is the correct facts are coming on the table. I must also admit that unfortunately, in last 6 to 7 years of IBC law, many such forensic audit reports, based on that, the RP has made an application for this transaction to the NCLT, but NCLT has hardly disposed of any such applications on merits. And therefore, it is for the government and the regulators to look at is that all such applications are disposed of in a timely manner. Because if there is a actual diversion of funds or actual preferential transaction which the promoters or the corporate debtor owners have done, then the money has to be recovered from them. But after a lapse of time, it becomes very, very difficult. And therefore, the timely disposal of such applications is also critical for the government and the regulators. The other part is the documents. And we as chartered accountants and auditors know the importance of the documents, particularly after the NFRA coming into force. The importance of documents, importance to compliance to auditing and accounting standards has become very critical. Similar way, our issue of notices for the COC meetings, taking of decisions by the COC, coordination with valuer, forensic auditor, coordination with legal experts, lawyers on certain matters becomes very, very critical. And therefore, the role of a secretarial is also important. And I'm aware that many chartered accountants play this a critical role of supporting on a secretarial part and maintaining the documents for the RP. And as I said, that once the requirement of documents and secretary records is critical, those documents and the papers, the IP, would be expected to maintain even after the CIRP period. If something goes wrong tomorrow, the regulators or the NCLT can always come back to an RP and say that what did you do during your period of performing the role as the resolution professional. And therefore, the maintenance of documents, maintenance of secretarial records, maintenance of notices, verification of claims, all these records maintaining becomes very, very important. Either you maintain physically or you maintain in a digital form, that is not an issue, but you should be able to maintain these, and if required in future, you should be able to find out from your records about what role you perform as a resolution professional. The next role, and rather than a role, it is more about your activity as a resolution professional. I personally believe that as a professional, any professional activity which you do, you must do on a full-time basis. I am aware that many professionals are feeling that let me explore the possibility of becoming an IP. Let me explore the possibility of supporting the IP on different roles like forensic valuation, accounting, verification of claims, etc. But then I personally believe that that role should be on a full-time basis and not on a part-time basis. Because unless there is a full-time role and unless there is a seriousness to a professional activity, unless there is a passion for the professional activity, one is not able to deliver a quality. And initially, there were many in India, the IBC law, what Dr. Sahoo earlier said, it was a very nascent stage in initial 16, 17, 18, 19. But after 8 years of the IBC, law is reasonably matured. The government has undertaken number of steps, and maybe to my understanding, this would be the only law where multiple amendments in the law has been made, multiple amendments in the regulations have been made based on the experience, based on the expectation from the market forces, and based on the expectation from the potential buyers and the corporate debtors, so that the principles of going concern, the principles of maximization of value, and the principles of the company getting and being taken over by good potential entrepreneurs is continued. And therefore, every professional activity I would suggest to follow on a full-time basis. I understand a chicken and egg story that unless you have some good IP role, how can you do away with your existing practice? But I would believe that every professional would have some gestation period, and if you perform well, if you do a good work and understand the IBC law, understand the peripheries and the supportive role which a chartered accountant can play. Because to my understanding, the chartered accountants understanding of finance, understanding of accounts, and understanding of tax, these all the three combination plays a very good role compared to many other professionals. And therefore, you must follow a full-time role rather than playing a part-time role or a need-based role. Otherwise, one is not able to perform with quality and with passion. The second suggestion on a conflict of interest. Many times, the RP, when he wants to appoint somebody to do forensic, he would go to his either an associate firm or to his very close friend. I'm not saying that very close friend cannot be appointed as a forensic auditor, or a very close friend cannot be appointed as a valuation or valuer. But what my only suggestion is that since the role of an IP is very, very critical, he's actually playing with the money of the corporate debtor. He is actually a decision maker by signing the checks. and making the payment and taking the business decision, you must follow a strict conflict of interest rule so that at least the third party supporting either a valuer or a forensic or any other role which you are engaging a third party consultant, that should be very clear demarcated role. Because as I said earlier, ultimately the IP is responsible and he cannot delegate his powers. What he can delegate is only certain supportive role. And therefore, to avoid any conflict of interest would be very, very important under the IBC law. And we have seen in the past that IBBI has levied a penalty, has reprimanded many such professionals for involving into conflict of interest on his role as an RP. The next important part is about the integrity and ethics. We hear from the market, we hear from certain IBBI decision on levying certain penalty on certain IP about certain unethical practices being performed by certain resolution professionals. As a professional, whether it is a role of an RP or whether a role of a valuer or a forensic auditor, or whether we perform our traditional practice of audit or tax. In all these practice, the integrity and ethics are most important. The Institute Code of Ethics, which we are all expected to follow, is very, very important. Particularly when you are playing a role of a resolution professional, the ethics and integrity becomes very, very important. There are certain incidents in the past where certain RP collude with the promoters, and then ultimately the interest of the corporate debtor is not satisfied, and there is no maximization of value, or there are sharing of certain confidential information. And therefore, my only request to all the members is that one should follow a strict integrity and ethical practices. Ultimately, the government, the lenders have put on a trust on the chartered accountants and other professionals to play a critical role of the resolution professional and as an IP. And in this process, if we follow our role as with integrity and with ethics, without having any conflict of interest, I think the role of a chartered accountant becomes very, very important and very, very. I think in summary and nutshell, if chartered accountants are able to play multiple roles of playing as an RP or in a supportive role to the RP in discharging his duties as a resolution professional. And in each area of practice, there is a tremendous opportunities. There is a tremendous role which one can play, grow the practice and grow the professional, and ultimately support the government in success of the insolvency professional law. Thank you very much.
Uh, uh, Anilji, may I now request you to present your views?
Thank you very much. And I think the stage is already set by Dr. Sahoo, by Dhinal Shah, and thank you very much to Bombay Chartered Accountant Society, my friend Anand Bhatia and Kinjal Shah for introducing me. So my role today is to give a little bit of view about the various key judgments of Honorable Supreme Court on the IBC. I would say that the Supreme Court has actually done a wonderful job so far for implementing the Insolvency and Bankruptcy Code in India. And there are various issues which has already been resolved by Honorable Supreme Court, and there are various other issues which are still pending before the Honorable Supreme Court. We would be discussing some of the resolved issues and some of the issues which are still pending before Supreme Court and actually need a very, very urgent attention of Supreme Court so that this all these litigations can actually be put at rest. So first of all, I would say in brief, some of the decisions which has already been finalized by the Supreme Court, and that is, in fact, one in the case of let the although the law was not very clear, because see, this provident fund and the gratuity is something which is a welfare schemes of the workmen and employees. Even the law was not very clear. Still, the Supreme Court has finally decided, and it is a law now, that in a resolution plan or in the case of a liquidation, the provident fund dues of the workmen and employees has to be paid in full. The gratuity dues of the workmen and employees has to be paid in full. So this was decided by the Honorable Supreme Court in the case of Jet Aircraft Maintenance Engineers Welfare Association versus Ashish Chausharia. That was decided in this case, and also in the case of State Bank of India versus Moser Bear Karamchari Union, that was decided in February 2023. But as of now, I'm attending to those issues which have been decided by Honorable Supreme Court, where the law was not very clear. So in the case of State Bank of India versus Moser Bear Karamchari Union, the Supreme Court decided in February, on 7th February 2023, that the provident fund dues and the gratuity dues has to be paid. And later it was also decided in the case of jet aircraft maintenance engineers. One, because in the case of Moser Bear, it was a liquidation case. And in the case of jet aircraft, when this judgment came, it was a resolution plan issue. So in both, in resolution plan as well as in the liquidation, the provident fund, gratuity, and superannuation fund, all the three things has to be paid in full and will not be considered as part of the liquidation estate in case the company goes into liquidation. And the resolution plans are also supposed to be compliant to these judgments. In case the resolution plan does not provide for provident fund payment or the gratuity provision, then the resolution plan would be considered as non-compliant to the law. In the meantime, the Supreme Court has also clarified, one, in the case of Sunil Kumar Jain and others versus Sundresh Bhatt. Sundresh Bhatt was the liquidator of ABG Shipyard, and this judgment, of course, it came in this judgment also the Honorable Supreme Court has decided that the salary during CIRP would only be paid to those workmen who were working during CIRP or during liquidation as a going concern. In case the workers are not working, employees are not working, they are not keeping the company as a going concern, they are not assisting the resolution professional, that salary would not be payable. So their salary during CIRP would only become part of the CIRP cost in case they are working for the company which is a going concern, or they are assisting the resolution professional or the liquidator in case the company is a going concern. The same was also held in the case of Jet Aircraft Maintenance Engineers Welfare Association. That was also held again, like in case this company was not in operations during CIRP. So therefore, a claim of about 700 crores from the jet aircraft maintenance engineers, that was rejected because it was held that the claim would be payable to them as CIRP cost only and only in case they were working during the company and during the CIRP, and it was also as a going concern. So this has been completely now the issues are settled to a great extent. So there are issues which are still not settled and needs a kind of urgent attention of Honorable Supreme Court. Recently, there has been one case from Bombay High Court and that is in the case of Shiv Charan. Shiv Charan judgment is very important in this particular case. It was held by Bombay High Court that Section 32 capital A of IBC, in fact, provides a power to NCLT to pass order of releasing the attachment of Enforcement Directorate in case the conditions under Section 32A are complied with. This judgment of Bombay High Court, in fact, which was much awaited, because in India, there are many companies, including the companies belonging to Nirav Modi, Mehul Choksi, Vikram Kothari, Junjunwalas. See, and all these companies, the assets are attached by Enforcement Directorate under PMLA. And the creditors are in fact struggling. Those who had the security interest on the assets, they are struggling. And in fact, it has become something which is victimizing the victims. So what is the case against most of them? Banking fraud. And banking fraud is a scheduled offense under PMLA Act. Now, in this case, they have done a fraud with the bank, misrepresentation with the bank, and the assets were attached by ED. In fact, it was already mortgaged to the banks. So basically, it is victimizing the victims. So therefore, very recently, there is some change in the view of Enforcement Directorate. Otherwise, there are many such cases where the assets are attached and the company has gone into insolvency. So this judgment of Shiv Charan, and in fact, on 12th of August 2024, the Honorable Supreme Court has a kind of granted a stay on this judgment, and as the appeal was filed by the Enforcement Directorate against this judgment of Shiv Charan, so therefore this particular matter is pending before Supreme Court, which actually will help many cases to resolve. It will not become a case of victimizing the victims. The asset value will not diminish, because see, these assets are attached for so many years now, maybe in some cases 5 years, 6 years, these assets are attached. So therefore, there is no value which is being realized by the stakeholders, secured financial creditors. However, based on this judgment, the NCLAT, Appellate Authority under IBC, has given a judgment in the name of Vantage. In that judgment, also it is held that in case the resolution plan is approved or the assets are sold and the conditions under Section 32A complied with, then the NCLT, adjudicating authority, has the power to detach the assets and hand over the assets on a clean slate to the auction buyer or to the successful resolution applicant. So this is one issue which is pending before Honorable Supreme Court, and this will actually resolve many issues. Now, the other issue which is pending before Honorable Supreme Court is one case which is in fact my case, that is the Kotak Mahindra Bank Limited versus Technology Development Board. Now, the original judgment which came from NCLAT was Technology Development Board versus Anil Goel, the liquidator of Gujarat Oleochem Limited, which is me. In fact, I distributed the proceeds from assets to the secured creditors while considering the priority of their charges and also the value of their security interest. So when I did this, I relied upon the earlier judgment of Honorable Supreme Court in 2005, that was the ICICI bank judgment, Sidco Leathers versus ICICI Bank. In that case, it was held that while the liquidator will be distributing the proceeds, the priority of charges, that means the first charge, second charge, subservient charge that would be considered by the liquidator, and also the value of security interest of each of them would be considered by the liquidator while distributing, although that was the case under the Companies Act. But more or less, the distribution pattern is the same, other than the tax dues. Otherwise, more or less, the distribution pattern is same under the Companies Act as well as under the IBC. Now, this also is something which is pending before Honorable Supreme Court. So, the NCLAT view was that once the assets are relinquished in favor of the liquidation estate by the secured creditors, then everyone will file their claim and the distribution will be proportionate to their claim vis-a-vis the total amount recovered. There will not be any kind of consideration for the first charge holder, any priority to the first charge holder. There will not be any priority for the second charge holder in case of existence of subservient charge holders. And also there will not be any consideration for the value of security interest. Now, when I say value of security interest, means that in case a person has the security on the mortgage of the land of the company, where the market value is 100 crore and the total claim of that bank is, say, 90 crore. So according to my distribution, he will get 100% because he has the security interest. On the other hand, a person who has actually funded working capital and his total outstanding is 200 crore and the total value of the current asset is at only 20 crores. So therefore, he should get 20 crores, because otherwise this will create a huge disturbance in the economy, and otherwise it will be very difficult for while the new breeds of the banks are lending against securities. So that actually will not happen in case this law prevails. So this particular judgment was given by the NCLAT. However, that judgment was in fact stayed by Honorable Supreme Court, while the appeal was filed by Kotak Mahindra Bank versus BC Technology Development Board. Although Kotak Mahindra Bank was not party to this particular distribution, Kotak Mahindra Bank was not even a party as a stakeholder of Gujarat Oleochem Limited, but because this was impacting all the banks in India, especially the new breed of banks, so they filed an appeal, and that appeal is pending since 29th of June 2021 before Honorable Supreme Court, and therefore this matter is pending. So this is also something, in case the Supreme Court decides on this matter, it will resolve many litigations which are pending, and those litigations are how the distribution is being done by the liquidators. Some liquidators are distributing in one manner, some distributors are distributing on the other manner. Similarly, when a person is having a specific exclusive charge on a property and he wants to dissent from the resolution process, a resolution plan, he is also not getting the proper value of the security interest because of these judgment of NCLAT and also for Amit Metallics. So these are two things that I wanted to say. One, what are settled and what is still pending with the Supreme Court. Now, the one judgment which I think is the last judgment, which is given by the then Chief Justice of India, Dr. D.Y. Chandrachud and J.B. Pardiwala and Manoj Mishra. And that judgment is, in fact, is in the name of the citation of the judgment is Murari Lal Jalan and Florian Fritsch, and that is again in the case of Jet Airways, when this company in fact was in the CIRP. The Jet Airways Limited in fact went into CIRP, and then there was the resolution plan was approved, and in the resolution plan there were some conditions precedent. So this was the first resolution plan which was approved as conditional resolution plan, and the condition was that the air operator certificate, which is normally called AOC, that would be available to the company. Then only the resolution plan would be implemented. In fact, there were 5 conditions, and air operator certificate was the main condition, that in case the air operator certificate would not be granted to Jet Airways, then the resolution applicant will not be uh, uh, obligation, will not have any obligation to kind of implement the resolution plan. So, in fact, there was a delay in implementation of resolution plan. There was first appeal to the Supreme Court of India, second appeal to the Supreme Court of India. In fact, there are in fact 4 appeals have gone to Supreme Court of India in the case of Jet Airways case. The various issues which in fact has been decided, and various issues, finally this company had gone to liquidation, but there is a lot of learning that we can see from this case, and some of these learnings that I would actually be explaining it today, that these learnings we need to see. One learning that the Supreme Court has said in this case, that this performance bank guarantee, which is given by the successful resolution applicant, that cannot be adjusted as kind of payment towards the whatever is offered in the resolution plan. This performance bank guarantee cannot be adjusted against that. And Supreme Court finally said very clearly that this performance bank guarantee should be till the resolution plan is completely implemented, and it cannot be adjusted in between any time. That is the final which the observation has been given. And timely implementation, because see, this resolution plan was not implemented timely. There were in fact 5 times the extension was given by the court, and finally also this resolution plan could not be implemented. But finally the Supreme Court said that the final deadline for the compliance by the successful resolution applicant, and then it was saying that it must meet the ends of the IBC. The timely implementation is the key. And in the meantime, the liquidation as a last resort, that also has again been reiterated by Honorable Supreme Court, that the liquidation is the last resort, and it is the but yes, there has to be some kind of flexibility in understanding that the timely compliance is also one of the requirement, because this IBC is for rehabilitation. The intent of the IBC is rehabilitate, resolve, and again kind of generate the GDP of the country. So the liquidation actually should not be considered like liquidation is the easy decision. Liquidation is the difficult decision. Then it also very clearly said that the employees' dues, including provident fund and gratuity, must be paid in full as per the statutory requirement. Even if the resolution plan proposes partial payment, non-compliance of these statutory dues can invalidate the resolution plan. So therefore, the employee-related regulation must be there. And finally, the court also said in this case that the COC's decisions are final on commercial matters. They must align with the statutory provisions to gain judicial approval. This provides a balanced approach, respecting COC autonomy while ensuring statutory adherence. COC cannot violate any kind of law or regulations only because the COC's commercial wisdom directs them to do that. And it is also held very carefully that the role of judicial oversight is very, very limited, but is very important. Limited, but very important. This is the, and like for interpreting the IBC, for interpreting various provisions of IBC, the role of the court is very important. And also one part which is important is that the monitoring committee must be constituted. The role of the monitoring committee is very important, and it was directed to IBBI that the monitoring committee role must be enhanced or clarified. So, in fact, the decision of the Supreme Court in this case regarding monitoring committee was that the monitoring committee underscores the importance of structured compliance oversight in insolvency proceedings, ensuring the successful resolution applicant is held accountable for meeting resolution plan milestone, and the monitoring committee would be responsible for timely implementation of the resolution plans and also compliance to all the provisions of the resolution plan. Therefore, the Supreme Court, in fact, finally decided in this case that the company may be liquidated and whatever they have already paid, that will be forfeited. So this is something which is kind of a very, very important and recent judgment. So another important judgment that I would like to discuss today is the Byju's judgment. Byju's, in fact, this judgment is also from the erstwhile Chief Justice of India, Dr. Justice Dhananjay Chandrachud. The name of the citation of the judgment is GLAS, GLAS Trust Company LLC. In fact, this is a trustee of securities versus Byju Ravindran. Ravindran is the promoter of Byju's, and the Byju Ravindran is the respondent in this case. Now, the Supreme Court, in fact, was dealing with two key issues in this case. The history, the kind of some of the facts that I would like to tell you. However, I would actually say, first of all, what are the decisions, the law points that the Supreme Court attended very carefully in this case is whether NCLAT correctly invoked its inherent powers under Rule 11 to approve a settlement agreement and set aside the initiation of CIRP. This was the one law point. And the second law point was whether the appellant, the financial creditor who was not a party to the settlement between the corporate debtor and the operational creditor, had the right to appeal the NCLAT's decision. In fact, the court, in fact, decided that, in fact, this is a very, very powerful judgment which says that the 12A section was added to IBC. The use of Rule 11 was, in fact, it started before this 12A section was added, and the respective regulations 30A, 30 capital A was added in the regulations. So this Rule 11, it was basically used when these two provisions were not there in the IBC. So therefore, it was being used. So now, since we have Section 12A and we also have Regulation 30A, so therefore, the use of Rule 11 of NCLT rules or NCLAT rules should not be used, and we should actually do everything as per Section 12A and as per Regulation 30A of IBBI regulations for corporate. Now, in this case, this company, which is Think and Learn Private Limited, which is the Byju's, the education company, which is a very, in fact, large company. The Board of Control for Cricket in India, BCCI, was the operational creditor, because when this some sponsorship, in fact, was contracted by Byju's with the BCCI, and a sum of rupees 165 crore was supposed to be paid, and then it was not paid. So, in fact, the Section 9 application was filed by BCCI and it was admitted. And finally, there was a settlement agreement, and NCLAT approved the settlement agreement, and then the CIRP was, in fact, closed because of this settlement agreement. Now, in this particular case, the GLAS, as I said, the name of the company GLAS, which is basically a trustee. GLAS Trust Company is a trustee company holding securities on behalf of some of these secured creditors overseas. So that particular GLAS filed an appeal objecting the withdrawal of the application, objecting the settlement between the BCCI, and the objection again was raised that Section 12A of the IBC and Regulation 30A of the CIRP regulations deal with the settlement of claims, after CIRP is initiated, and none of these provisions are complied with. So, and then in fact, finally, the Supreme Court held in this case very, very important decisions that the Supreme Court has given, that the NCLAT should have stayed with the constitution of the Committee of Creditors and directed the parties to follow the procedure in Section 12A, read with Regulation 30A of the CIRP regulation. That's what Supreme Court held, saying that NCLAT has erred in invoking its inherent powers to approve the settlement without following the prescribed procedures for the withdrawal of the CIRP. In fact, when we see the past a few years, whenever there is any insolvency starts, the promoters or any other person will file an appeal and will try to delay and will try to kind of say that we are settling, we are settling. So therefore, the Supreme Court has actually put all these cases at rest, saying that in case there has to be a settlement, it has to be exactly as per the procedure mentioned in Section 12A and Regulation 30A, and where the total procedure is divided into, total process is divided into 4 parts. And those 4 parts are, 4 stages are very clear. One is the stage 1, before the application under Section 7 or 9 or 10 is admitted by NCLT. So it is very clear that the application is not admitted. So considering the withdrawal, NCLT typically restrict its inquiry to these parties, as others are not yet stakeholders. So therefore, the NCLT may allow the withdrawal. And the second is after an application under Section 7, 8, Section 9 or 10 is admitted, but before the COC is constituted. Now, in this case, if the application is admitted, but the COC is not yet formed, then this applicant can seek withdrawal by submitting a request through the RP. So this form FA, it has to be submitted through the RP, and then only it can be withdrawn, and no voting is required, but the COC is not constituted. Then after the application is, the third stage is when the application is admitted and the COC is constituted, then 90% of the voting is required, and the entire procedure as per Regulation 30A has to be followed. And even fourth stage is when the EOI, the expression of interest for resolution plans, has also been invited. So that also, it has to be 90% voting, and thereafter the reasons has to be given why at this stage withdrawal, why not earlier. So this is also a very, very important judgment. So I'm not sure how much time we have, but then I have judgments, and even we can even open something which is for a kind of a question answer session. So what the organization, the organizers like the Kinjal, Shah.
Important judgments, and then we will have a Q&A.
So I think we should have some time, then about 10-15 minutes is okay.
5 to 7 minutes, and then
5 to 7
5
minutes.
to 7 minutes for Q&A.
All right, 5 to 7 minutes. I will just mention the another important judgment from Honorable Supreme Court of India in the case of Greater Noida Industrial Development Authority versus Prabhjit Singh Soni. This judgment was given on 12th of February 2024, and in the some company like JNC Construction Private Limited was the corporate debtor. And in fact, the Supreme Court has held in this case, like there is a issue like the Supreme Court says that when we read the kind of law, which is the Greater Noida Industrial Development Authority is a government authority, and they have their own law. And in the judgment says that when we talk about the some kind of security interest is created by operations of law, and since the Greater Noida Authority is a government authority, and the observations, like they have a law called UP Industrial Area Development Act. So that act says that the that act says that this act provides a right. This act provides a right to the authority to kind of have a lien or have a charge on the property, on the land that they have leased out to the company or a corporate debtor. Therefore, after this understanding, the Supreme Court has said that this actually falls into the definition of a secured creditor. Have also held that a company which is a land owning company and has given the land on lease to the company, the corporate debtor, and also referred Section 13 and Section 13A of Uttar Pradesh Industrial Area Development Act, which is actually it accordingly it says that it is not inconsistent with the IBC, and therefore the overriding effect under Section 238 would not get attracted. So therefore, the Supreme Court says that the COC to consider the plan, ensuring proper classification of Greater Noida Authority as secured creditor and also a secured operational creditor, and then thereafter only the actually this can be resolution plan can be approved. So this judgment in fact has a lot of effect, because in many other cases the bench have started asking that if the land owners are having some rights, maybe though that right is having a lien on the land, or they have a right to cancel the agreement in case of non-compliances, that should be considered as their lien or their charge on the land, and their claim should be considered as secured operational creditor. So this judgment actually has impact on various cases of Noida and Greater Noida Authority, and therefore this is also applicable to various other cases where the landowners are having some dispute with the regarding the land. So the another case which is important, which is very, very recent, which is China Development Bank versus Doha Bank, that is dated 20th of December 24. It actually have resolved one issue, that even if the loan is not given to corporate debtor, even if the property of the corporate debtor has been given to provide a collateral security to an associate concern, by just creating a deed of mortgage, if there is a commitment that the total amount of loan will be paid, that will be considered as a corporate guarantee, that tantamount to a corporate guarantee, and that particular person in fact would become a financial creditor in case of the corporate debtor. So in case of that particular company which owns the asset, whereas the loan has gone to another company. So this is also a kind of a judgment which is very important, and it actually have resolved many other cases. So this is this is all that I have as far as the judgments are concerned. We can see in case there are questions, we can attend all the questions.
Kinjal, can I just make one small comment which I actually forgot?
Yes, please.
Okay. So one of the role we chartered accountant can also critically play is the preparation of a resolution plan on behalf of the resolution applicant. Now, normally these will include two parts. One, compliance to law, and preparation of the financial numbers, that what would be the appropriate amount which a potential resolution applicant can submit to buy over this CRP unit. And therefore, it would include a financial analysis about the future projections, what is the actual outstanding liabilities, what is payable to the creditors, employees, statutory dues, etc. And then ultimately, what should be the appropriate numbers which a resolution applicant should submit a resolution plan to the COC or the corporate data. And there's compliance to certain legal provisions. Again, I would believe that reasonably, unless there are some typical legal issues, a reasonable chartered accountant with an experience would be able to comply those legal provisions also. And therefore, this is one other important role which a chartered accountant can play to help in preparing a resolution plan. Thank you.
See, Dhinal bhai, one important part which I also would like to
Sure.
add, that the chartered accountants have a great role to play. See, when a successful resolution applicant takes a company, so he actually has two questions in mind: how much brought forward losses or unabsorbed depreciation I would be able to uh, kind of get the benefit.
Yes.
But once this section 41 subsection 1 is invoked regarding cessation of liabilities, and then also the amendment in section 28 subsection 4 of Income Tax Act that was in budget 23 with effect from 1st of April 24. So these two things have actually a kind of created a huge business or professional opportunity for chartered accountants, because see, every successful resolution applicant is now struggling whether he is likely to pay some taxes or he will get some benefit of the brought forward losses or unabsorbed depreciation. So it's a very kind of difficult calculation, although we have kind of with so much of practice we have kind of structured it, and we've done many such calculations where we actually want to see how much already have been allowed to the company as expenditure or as loss. We need to see one section 43B, how many losses are there, so what kind of current assets that. So it is a big opportunity for the chartered accountants to protect SRAs and also to give them some kind of solution to the problem.
That's correct, Anil. That's correct. That's correct.
Anilji, one question from the audience is, if there are any damages or interest that has been passed by the labor code, will that be also forming part of the provident fund use?
So there are like kind of conflicting judgments on this. The NCLAT has also said in one judgment that the damages or the penalty which is not going to the account of employees or workmen, that should not be considered as part of the provident fund. That should be considered as operational claim of an entity, of an organization, and can actually fall accordingly under section 53. But yes, recently I have seen even one of the judgment from NCLT Kolkata, which is still saying that even the damages also would be considered as mandatory payment of provident fund. But still, I feel that the judgment which is more acceptable is that the damages or penalty which is not going to the employee's account is not considered as provident fund part.
Dhinal, one question is that there are various aspects which an IP is required to possess before he accepts this professional assignment. Few of them you have already listed, which is soft skills, management skills. Can you just highlight on the important skills that in your experience chartered accountants need to sharpen further before they accept these assignments?
So I would believe, Kinjal, that the most important is the soft skill and understanding of the business. Because when you take over a corporate data, you are expected to run the business in collaboration with the existing promoters, staff, and the people. And I'll just give you a classic example. I was an IP of the shipbuilding industry, Bharti Shipyard. Now, I never knew what is shipbuilding. And we actually had to hire a CEO from a shipbuilding industry to run this business. It was having different yards across the country, which are completely open. There are all chances of theft of assets. There were all chances of local nuisance value in the villages. And if you actually go there, you actually face a threat to your life. And all these circumstances, you have to play a critical role. And there, as I said, it is a soft skill and a solution-oriented approach. if you are going to raise question, you are only going to answer. And therefore, simple answer is that don't raise questions, bring solution on table. And the other is that, as I said, every promoter would have a non-cooperative approach. When I entered Bharti Shipyard, I was told that you have to also bring tea and snacks from your house. We don't have money even to have a cup of tea for you. That is an approach to start with. And then you have to go along with those promoters to take the company to a next level. So I think the approach has to be very, very soft, understanding, but at the same time very firm, because at the end of the day, you are responsible for everything.
Dhinal bhai, Anil bhai, there is a question on GST related aspect. I mean, any one of you may answer that. It says, in case if an entity is under CIRP process and its GST liability is unpaid, whether ITC availed by the recipient of services disallowed under Section 16 of CGST Act, or it is treated as operational debt and can be recovered from the revenue generated from CIRP process.
I honestly do not have a correct answer, but to my limited understanding of GST law, that if the liability is unpaid, the buyer would not get a credit under the normal provisions of law. And therefore, it would be difficult. But I would request the participant who has raised this question to check up the correct law. I am not good on GST side.
Anil, a question to you. Of late, we have seen exodus of cases being filed against the IP, and it faces problems. I mean, the legal matters from almost all the stakeholders. What is your advice on a professional who is accepting this assignment? On how does he protect his legal liability?
It is exactly the same as what is expected from NFRA and institute from an auditor. Your documents, and it is not about your actual role as an RP. That, see, as I said earlier, even if you don't accept a particular claim, a creditor will go to NCLT and say that particular RP is not accepting my claim. There are disputes between employees' dues, and then they will go to the court. There will be disputes with the regulators. See, in initial years, now at least people understand IBC. In the initial years, the electricity connections were disconnected for non-payment of electricity dues. I actually received a summons from police for non-payment of provident fund dues. And there are instances where certain RPs were actually caught by the police and put behind bar for some hours. So it's a very, very interesting role and very challenging role. But I think one will have to perform and show his bona fides, that what he acted is in good faith. And that is a law under the IBC, that if he is able to show bona fides in good faith and supported by our documents, then I don't think in all these IBBI related cases against the RP and the NCLT is mainly related to the conflict of interest and certain lack of documents to demonstrate a good faith.
I think
Anil
I have to just, I think Dhinal has correctly answered it. I can only say that the intent of the insolvency professional is very important, and also how that intent has been recorded in the documents. To sum up, the documents are more important, even if the case is before NCLT or it is before IBBI. If we are able to submit the documents, in case we are able to present ourselves, then I don't think there will be any challenge. But in case there is a like kind of a compromised intent and also the documents, But then the two things, that one, intent has to be very clear, and also whatever is your intent, that has to be documented very correctly.
And just to add one example, Kinjal, that suppose I am an auditor. If client gets me a valuation report, now I am not supposed to be an expert on every subject. But at the same time, the Auditing Standards Institute regulator expect that I should prima facie make a judgment that whether our valuation numbers are reasonably correct. I may not be expert on what is the beta rate and what is the cost of capital, but a reasonable gut feeling professional judgment. The same thing when in one of the case, I was an RP, and when a valuer gave a report, the NCLT actually asked me point blank question, did you verify the valuation report and what the value is? So the question is, I am not expert on valuation. I am not expert on what is a circle rate. Ultimately, it is a role of a valuer. But prima facie, it is my role and responsibility to be satisfied.
Good.
Thank you, Anilji. Thank you, Dhinal bhai, for answering all the queries of the members. And before I propose a well-deserved vote of thanks to both the speakers, announcement on the forthcoming programs of the BCS. Friends, we have a program on which is an AIF conclave on 17th and 18th of January in Mumbai. The registration is overwhelming and it is closed. We have a 20-second residential refresher course. The details are available on the BCS website. There is a webinar on the recent important decision under the Income Tax Act. A fireside chat on the return of Trump. What does it mean for America, India, and the world? And a 58th residential refresher course, which is the flagship program, which Dhinal bhai was referring to. This time, that is going to be at Lucknow with a special visit to the Ram Mandir, which is from 26th February to 1st of March. The 13th residential study course on Indias, and the Canva course for the young and budding chartered accountants, which is from April 11 to April 13. May I request all the participants to visit the website and follow the social media handle of BCAS for all the forthcoming programs. And now coming to the pleasant task of proposing a well-deserved vote of thanks, Dhinal bhai's comprehensive overview of the responsibilities, challenges, and opportunities for professionals in this field was really invaluable. We are particularly grateful for his candid discussion on the practical hurdles faced by the IPs. And the Dhinal bhai's checklist of do's and don'ts has provided a deeper understanding of the intricacies of the insolvency and restructuring law, backed by his practical experience and examples. We are also deeply indebted to CA Anil Goel ji for his enlightening presentation on recent landmark judgment. Anil Goel ji shared crucial Supreme Court judgment like the Moser Bear judgment, the Jet Airways, Baiju, ABG Shipyard, summarizing their profound impact on insolvency practices. These judgments of Supreme Court as well as Appellate Tribunal, many of which stand to the credit of Anil ji, have not only settled the important legal questions, but he also shed light on the areas requiring further clarification. On behalf of the Bombay Chartered Accountants Society, I extend our sincere gratitude to Dhinal bhai for his insightful presentation on role of chartered accountants under IBC, and CA Anil Goel ji for his talk on the recent landmark judgment. I also thank Sahoo ji, and thank you Dhinal bhai and Anil bhai for your valuable time and contribution for today's session. Thank you.
Thank you.